Welcome to the Future of Payroll and Workforce Management Insights by HR.com, your go-to resource for insights into payroll and workforce management. From navigating compliance and technology trends to exploring the latest in global payroll solutions, we're here to keep you ahead of the curve. Join us as we dive into the forces reshaping payroll and share practical strategies to optimize your workforce management. Let's get started.
Well, hello, everyone, and welcome to the latest episode of Future of Payroll and Workforce Management, a podcast here at HR.com, where I am your host. My name is Brent Skinner, and my guest today is Gina Dorcelus, who is U.S. Legal Counsel and Senior Director of Global Employment for Papaya Global. Welcome, Gina.
Thank you so much for having me, Brent. It's a
Oh,
pleasure.
yeah, absolutely. This is going to be a really interesting episode. We hear a lot about EORs and all this kind of stuff, and it's all about hiring correctly and employing people correctly. But one thing that's not talked about as much is how do you fire people, terminate them correctly, or offboard them, however you want to put it, globally. Like all the rules are different in the various countries across the globe, and we're going to talk about that, and I'm really looking forward to it. But first, as I like to ask all my guests, and you are no different, what is it that got you into the human capital management space, the world of work space? I find that there's a lot of passion in this space, and I'm always curious, keen on learning the various guest stories.
Yeah, so I'm glad you asked. My background is primarily was in employment litigation. So I have a background of representing employers namely the city of New York in my past life at the New York City Law Department, doing discrimination cases, unjust termination cases, harassment cases. And then I made a lateral move and transitioned in-house, keeping and using that knowledge in the EOR space and employment law. And it's just so great to be able to bring that litigation aspect and from seeing all the terminations in the courtroom to bringing it in-house to Papaya Global.
Yeah, that's a cool backstory. That's a really, really impressive background that you have. And Papaya is fortunate to have you. Let's get right into it. So let's kind of set the table here that, working with an employer of record, sort of the idea is that a lot of folks they go into it thinking, okay, I'm going to sort of, offload my risk here. The EOR is going to take it on. And that's not true, but it's a little bit more complicated. Where does legal responsibility actually begin and end when it comes to an EOR, specifically vis-a-vis sort of termination decisions made across different countries?
Yeah, that's a really important question. I think it's one of the biggest misunderstandings. And just putting things into context now, we see that more companies are hiring globally more than ever, especially in this post-pandemic world. And companies are retaining EOR services thinking that they're outsourcing risk. However, essentially what you're outsourcing primarily is the administration services, the HR services. The risk still is on the company. People assume, or companies rather, assume that the EORs are not liable, but the company is still the one who determines who gets terminated and why as they're managing the workers' day-to-day activities. So it's not necessarily on who is the legal employer, but whether the contract matches the reality, who is controlling the workers' decisions. Therefore, the liability still is on the client. For example, in countries such as Italy, where you have a client that wants to conduct a redundancy, and that end client thinks, well, we have the documentation, we're prepared, we have the business reason. However, and the EOR may push back a bit on that, and the client proceeds and terminates that worker. they get surprised when they, get a claim for unjust termination or unlawful termination, and the EOR is the client is still involved. Whereas in Italy, local law requires real world documented justification. The responsibility doesn't disappear just because the EOR is the one that signs the paperwork. It just shows up later as a contract dispute between the client and the EOR. So therefore, to answer your question, the EOR doesn't eliminate liability. It just reallocates it.
Yeah, that's really interesting. Um, First, a question, just for our audience, for those who don't know, what is a redundancy?
So a redundancy is typically in certain countries is where a client or a particular company wants to eliminate a position. The role is essentially redundant. It's no longer required. So in certain countries, they call it a redundancy process. There's certain countries where a redundancy process is required. For example, in countries such as Australia, you have to consult with the workers. You have to conduct an investigation to ensure that there are no other roles that exist within the company. And you can understand that when you have a client, a company, and an EOR, the question is, which organization is the role redundant? Is it for the EOR who may engage other clients, or is it for the end client? Typically, when an end client wants to terminate a worker for redundancy, is because there is no longer a position within that company. However, that position may still be available within the EOR. So it gets very tricky. And in those circumstances, redundancy may very well not be a ground because you can't demonstrate that there's a redundancy with the EOR. You can only demonstrate that there's a redundancy with the end client.
This is a real world example of a technicality. I mean,
Right.
that is, wow. So I have another question around this, just sort of an observation. There's what's known as at will employment. You see it sometimes in the United States. Is that something that's even a thing worldwide anywhere, or is it sort of a just us here in the United States?
So it exists, but I would say we are few in between. At will employment is not, well practiced globally, especially in countries in the EU. There's typically severance required. You have to have a valid ground for terminating workers, whereas in the US, you can terminate workers for any reason, absent a discriminatory reason, right? You can't terminate workers based off of their gender, race, religion, and there's also specific state statutes. But otherwise, you don't need to demonstrate a redundancy, absent there being a contract designating notice requirements. You don't need that. But in other countries, there's minimal requirements. There's minimum notice requirements, minimum service requirements. Automatically, you have to demonstrate that you meet these requirements. So I would say U.S. is in a case of its own.
Yeah, yeah. A couple of years ago, I was working sort of in the background with a content agency, helping them just develop sort of some landing pages for EOR curious people for the various countries out there, and what all the various requirements from a top level, sort of you wouldn't want to go to these landing pages and just, oh, this is what I have to do, and just go it alone. Definitely don't want to do that. But I was struck by how strict the rules are in
Right.
many, 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 many countries, most countries, when it comes to termination. Across jurisdictions, let's kind of like drill down a little bit here. So, what are the most common mistakes organizations make when managing EOR employees? How can HR, legal, payroll, and business leaders work together to reduce those risks before they become costly disputes?
Right. So what I see very frequently, and especially if we're talking about companies and some of my clients that are in the US, I see primarily is treating EOR employees like their direct employees,
Mhm.
right? So in the one sense, these companies have good intentions because you don't want to discriminate against workers, but you do want to keep in mind that these are not your direct workers. And to give you some real world context is that often I find that clients or companies, for example, when you have an issue with a worker that is not performing well, they will issue warnings to the particular worker as if it was their direct employee. They will change the terms of the contract without regard to local legislation, without regard to the local law. They will even terminate or offboard workers or put in documentation that these workers' services are no longer needed. And as we indicated, that in certain of these countries, there needs to be a ground. You need to provide severance. You need to provide notice. And these are all being done without looping in the EOR or involving the EOR. And more often than not, local law requires specific documentation, consultation processes, notices. And just to give you an example, just thinking about a U.S. team member or manager that has an EOR worker, an employee in Germany, and their performance takes a dip, for example, and this particular client provides a verbal warning to the worker. There's no written record. They fail to include what is known in Germany as a works council. Like, for example, they can have an election of employees who inform the workers of their rights, similar to a union. That's this particular right in Europe. And doing this process or performance without notifying the Works Council is a problem. So essentially, courts expect well-documented evidence of this. So that I would say that's the first mistake I would see. The second biggest mistake I see is that most clients focus on having a valid ground. Like, let's say if we do pass the hump of having a valid ground, they don't focus on the process. So it's not just enough to have a reason. Let's say you go through the correct redundancy or you have the correct performance improvement or documentation in place. You must follow the process. For example, in the situation of Germany, if there's a works council involved, you must notify the works council of the performance issue. You must notify the works council of this redundancy process. So these are some of the mistakes, the big mistakes, the reoccurring mistakes I see. Treating the EOR employees like your direct employees and not following the process enough. The fix is rather simple. It's really simple. It's just including your legal before decisions are made. What happens, I find, is that you find companies that make these decisions without regard to local law, without regard to the EOR process, and they will inform the EOR after the fact. We terminated this worker yesterday. It comes across as a big shock. So just involving the respective parties earlier. Also, getting your payroll teams involved from the outset and giving them visibility so they can factor in any severance calculation, any notice calculations. So no one is blindsided by any figures. Instead of treating the EOR as an early warning system, as opposed to treating the EOR as someone or just a party that just validates the paperwork.
Yeah. That is amazing to me that anyone using an EOR would do anything with those employees employed through the EOR without doing that through the EOR. That blows my mind. And I don't know if there's anything to say about that except that I'm surprised.
It happens all the time, believe it or not. Like, companies, they're very well, they have great intentions. However, you must think about there's so many different stakeholders within a company. You don't know who's involved in onboarding the worker. It's just a lot of miscommunication at times, and there's a lot of pressure to offboard workers. And let's think if a company is going through a reorganization, it happens quite a bit.
Well, fair enough. Just goes to show if you're working with an EOR, get your money's worth,
Absolutely.
If you you could give multinational employers one framework for approaching employee terminations globally, what principles would help them balance business objectives, legal compliance, local employment requirements, while avoiding unnecessary exposure? Like, is there like sort of like a guiding a North Star that you can have here?
Now, if I were to leave companies with three, I would leave them with three principles. First, they need to validate the grounds, know why you're terminating. For example, in countries such as the US and the UK, what is considered cause or performance issues is not considered the same in Italy. So you must ensure that the ground and the basis is valid in the region in which the worker is based, in conjunction in the support of the EOR, because you will be blindsided by severance obligations and a process that you didn't account for, that your HR teams, and that's a difficult conversation to have with C-suite after the fact. So you want to first validate that there's correct legal grounds. Secondly, another principle is documentation. Document. Must be an internal paper trail. Because one thing that you can forecast in general with a basic Google search, basic AI search, the general severance, the general notice that is required in a particular country. But what you can't forecast is when workers are going to file claims for undismissal or for very employee friendly regions or litigation. Lack of documentation can simply only hurt you. Make sure that you're documenting internally with your teams. What is the thought process behind a redundancy? What is the thought process behind a performance plan? Making sure that there's true consultation processes followed, and having that documentation that can support and assist you. If I were to leave another principle, is just the timing. Factor in the timing to lawfully offboard these workers. There's typically, and especially in the US culture, a mindset that the terminations are a quick exit, but it's the complete opposite around the world.
Yeah.
Like, for example, in countries such as APAC or as in Japan, there must be a strong, reasonable basis. And these countries are very court employee friendly, factoring the time for consultation processes, right? In countries such as Australia, this may be a 3 to 4 week process, right? So you really want to factor in the time to consult and to negotiate. Those are the main three principles that I would provide.
You did mention, severance, and again, having seen some of those laws across that, believe me, folks, the severance requirements can be quite a bit. So it's I guess just putting an exclamation point on that for you. It's very important to have your ducks in a row, to be cognizant of this. And what I'm hearing you say is, engage with your EOR. If you have one, you really engage with them. Utilize their expertise to help you navigate some of these potential pitfalls. Gina, thank you so much for being a guest on the podcast. This was very, very helpful and informative conversation.
Thank you. Thank you for having me.
Thanks for tuning in to the Future of Workforce Management and Payroll Insights by HR.com. We hope today's episode brought you valuable insights and fresh perspectives on the future of payroll and workforce management. Be sure to check out more episodes and explore resources at HR.com/podcast or wherever you listen to podcasts. Until next time, keep innovating and making a difference in the world of payroll and workforce management.